Good afternoon. Good afternoon, everyone. Welcome to our CLE for today, the Florida Bar Section CLE on taxation of private trust and companies. Before we get started, we have a few housekeeping announcements. You can find more information about all the programs in our newsletter and also on our website. Our fellowship program is back. This program is designed to help new tax attorneys with mentorship and learning opportunities. You can apply online and make sure you do so before the March 1st, 2025 deadline. Another announcement, our 2025 Directors Meeting is taking place January 24 through 25th at the Pier House Resort and Spa in Key West. Everyone is welcome to attend. We also have a Tampa tax section lunch on January 22nd, 2025. It's featuring Paul Esley, Chief Tax Strategist at the Northern Trust Company. Please come and attend. Make sure you're able to get the insight into the latest developments in federal tax law regarding private investment and wealth management. It is a CLE accredited program, and it will be from 11:30 to 1:30 p.m. at the University Club at Tampa City Center. Make sure to check it out if you're in the area. There's also the International Tax Conference that's happening in early January. Boot camp is January 8th, and the conference is taking place January 9th through the 10th. The ITC's featured speaker is Bradley Birkenfeld. He is an international banker and wealth manager at the UBS Bank in Switzerland, who blew the whistle on a massive tax evasion scheme and was awarded about $104 million by the IRS. We will now turn it over to our sponsor, Mercer Capital. Thank you very much for supporting the tax section. We appreciate it. Tim, over to you.
Thank you, Andrea. Appreciate your comments. Also, thanks to our speaker today, Osvaldo, and special thanks to our tax section program administrator, Whitney Bledsoe. Mercer Capital Management is one of the largest independent valuation firms in the United States. We were founded in 1982. We're based in Memphis, Tennessee. We're national in scope. We also have a significant Florida presence. Our office is located in Winter Park, Florida, centrally located. We're a full-service firm providing valuation services for closely held businesses and other financial assets for a variety of compliance, litigation, and transactional purposes. We have over 40 seasoned analysts with advanced credentials, including chartered financial analyst, senior accredited appraiser, and other valuation credentials. Our size provides us the opportunity to concentrate in industries. A couple of those are auto dealerships, registered investment advisors, and what's germane to today's topic, depository institution, banks, credit union, and trust companies. In the federal tax valuation silo, we routinely prepare valuations for estate and gift tax planning and for a myriad of income tax purposes. One of the areas that I think that our company excels is when we're talking with a legal advisor, that we can have a substantive conversation on the front end of a potential engagement to determine the best course of action. Whether or not that involves ending up in an engagement or not is, in my view, is kind of secondary, as long as we're able to provide some value to the attorney in their representation of their client and really essentially get them to the right place. So if you do have such a matter, feel free to give a call to our Winter Park office. And with that, I'll turn it back to you, Andrea, for the introduction today.
Thank you, Tim, and thank you for your support of the tax section. So today's CLE code is 8711. A reminder, the CLE is being recorded and you will be able to find it in the tax section's YouTube channel along with all of our other free CLEs. If you have any questions, please drop them in the Q&A and then we will answer them at the end of the presentation. Our speaker today is Osvaldo Garcia. Osvaldo is an executive director at JP Morgan Private Bank, working as a wealth advisor for the bank's clients in Latin America. At JP Morgan, Osvaldo supports clients on a diverse set of matters, including estate and tax planning, family governance, family office formation, and philanthropy. Prior to joining JP Morgan, Osvaldo practiced as a private client attorney, where he focused on international and domestic tax and estate planning, estate administrations, trust administration, tax controversies, and matters of international regulatory compliance. He has co-authored a chapter titled U.S. Tax and Regulatory Considerations in Private Trust Companies, a handbook for advisors published by the 2020 by Globe Law and Business. He has also written various articles and participated in panels relevant to the international private client. Osvaldo received his JD from Cornell and an LLM in tax law from New York University and a BA from Florida International University, magna cum laude. Osvaldo, it's a pleasure to present you today, and we are excited to have you presenting the CLE, and it's over to you.
Thank you so much, Andrea, and thank you everyone out there in Zoom land. It's really a pleasure to talk to the taxation participants. It's my first CLE for the taxation. Hope is the first of many. And I thought this would be a very interesting topic. It's a topic that's kind of near and dear to my heart because I have kind of seen the progression of this particular landscape since I started practicing. And that's with respect to private trust companies. We have seen that over the past decade, the use of private trust companies as the fiduciary for family trusts has seen an exponential increase. And this is in particular because many states have started implementing laws that facilitate the creation of non-depository trust companies that can serve as trustee for families and the trust that they have. The problem is that despite the increased regularity that we see with respect to these structures, it collides with what is a very scant understanding, not only from the IRS, but also from the legal community writ large, of the tax implications when you utilize these structures. So the idea with this CLE is to offer a survey of the state of play of PTCs that should hopefully give you an understanding of the risks and considerations of utilizing PTC. So the plan is to first define what is a private trust company, understand why these vehicles have become so popular. We will go over the typical private trust company structure and then survey the landscape of private trust company statutes. After that, we're going to go into the potential tax implications of using a PTC, which is most likely what you're all very interested in. And then we will take an in-depth look at the guidance that we currently have from the IRS and round that out with potential planning approaches. Lastly, we're going to conclude with a brief look at additional regulatory considerations that have to be taken into account when utilizing a PTC. And the idea behind this presentation is to give you working knowledge so that you can advise your clients regarding the use of the PTCs and also help them understand whether this is a right fit for them. So first things first, how do you define a private trust company? A very, very general definition is that it is a non-commercial entity that serves as fiduciary to one or multiple branches of a family without requiring a public trust company charter. Any public trust company charter is going to be subject to greater regulations. It's going to be subject to greater capital requirements, et cetera, because you're offering those services to the public. And what the private trust company statutes do is that they allow you to basically form this under very, very light regulation, or as we will see, very little to no regulation. It has to be non-commercial because the moment that you provide the service to the general public, it no longer qualifies as a private trust company, and it will be subject to the full extent of fiduciary regulation. But the fact that it is non-commercial does not mean that it does not have to be profitable. It could be profitable, but as we will see, this is not generally a type of structure that is used to generate profits. It's more than anything used to administer the affairs and the fiduciary structures of the family. It's also worth clarifying that a private trust company is not necessarily a family office, which is something that is very common nowadays in high net worth families, but it could be functioning as such in certain cases. The family could adapt the private trust company to function as the family office. Throughout the presentation, I'm going to refer to the entity as a private trust company, or PTC for short, but it is worth noting that some states call it by different names. Some of them call it a family trust company, others call it a private family trust company. In the case of Florida, where we have our very own family trust company statute, we call it a family trust company. And that statute became effective in 2015. The other distinction that we should note when talking about private trust companies is that they come in two flavors. One is what we call the regulated flavor, and the other one is the unregulated flavor. With respect to a regulated trust company, we're not talking about a full-on public regulated trust company, but instead it's one that is slightly regulated, but that is still under the supervision and regulation of the local state regulator. This could be, for example, the banking division. And so they have that type of trust company has to comply with certain requirements in order to be able to obtain that license and maintain it over time. This could be training for its officers, it would be background checks, it would be capital requirements, so on and so forth. We can go over those later on in the presentation. These tend to be light regulations, but they are regulations that need to be taken into account. And the regulation differs from state to state. Some states require a little bit more, some states require a little bit less. And then there's also the unregulated trust company, which is a creature that has most recently come to pass. And it's one where you can basically form an LLC and do not have to submit an application with the state regulator. And provided that you stick to the narrow services that it can provide, you have, for example, someone that is designated as a relative in order to define who counts as a family member, that you're not providing those services to a broader class of individuals than is allowed for, then it will not be required to obtain license. Not every state has this, but some recent states that have enacted statutes do have both variants, both the regulated and unregulated kind. Now, with respect to this, it is worth noting that not all states, and I would say most states, don't call it regulated or unregulated. You will hear it called licensed versus unlicensed. And I think more than anything, that's to avoid any kind of implication that there are rogue, unregulated private trust companies out there acting. So you're going to typically hear licensed or unlicensed or charter or non-charter private trust companies. Of course, it's worth noting that it's just good practice that even though an entity may not be regulated or unlicensed, it's still best practice to comply with as much of those requirements that are required for a regulated trust company so that you can have a properly administered private trust company. With that, let's go over to the next slide and we can explore a little bit more of why are we seeing more private trust companies in general. And here I have 5 general reasons. There could be more, but these are the 5 that I identify as the most salient ones. So the biggest one, and I think the most important one, is control. Families increasingly want to have a more hands-on role in their operations, which also applies to the management of the fiduciary structure. And the private trust company basically allows them to tailor their fiduciary as to how they want it to perform its functions. And they can hire personnel that fits the needs of the family and provide a certain continuity of operation within the family. And so the idea of not relying on a third-party fiduciary may appeal to what are increasingly more sophisticated families. That said, there is an inherent risk here, and one that I have seen in my experience, because families do not typically have the fiduciary knowledge to be able to manage trust. And so it is easy to see a family that is looking to cut costs on their fiduciary structure, establishing an unregulated PTC with a bare bones operation. That could be ripe for mismanagement of the fiduciary structure. It's also possible, and it's worth taking into account, that you can achieve potentially the same degree of control that the family wants by way of a directed trust at a fraction of the cost that it would take to run a well-administered trust company. And so consider whether that is a better option for your clients. It's worth noting that Florida, as of 2021, does have a directed trust statute. So you can now rely on that statute in Florida, same as other jurisdictions. Moreover, and this is the big crux of the conversation today, that control can jeopardize very careful estate and tax planning. So that's something that we have to discuss further, because it all depends on what guardrails you're implementing within the PTC in order to avoid that degree of potential jeopardy to the tax planning that has been carefully put in place. In short, I do think that there's going to be an increased litigation with respect to PTCs down the line, because these structures may not all be completely well structured. And so it's best to make sure that you discuss the pros and cons of using the PTCs with your clients and understand whether this is the right fit. The other reason that I see most often is privacy. Families want privacy, especially high net worth families are increasingly concerned about sharing information with third parties, particularly after leaks like the Panama Papers, Pandora Papers, so on and so forth. And in theory, reducing the amount of third-party providers can reduce the chance of a cybersecurity risk. I say in theory because in practice, that may not necessarily be the case. That mitigation may just be illusory. For example, in our recent study on family offices, JP Morgan found that 40% of family offices see cybersecurity as a gap, and only 10% of US family offices actually have a chief technology officer in place, which would be the individual in charge of putting cybersecurity measures in place. That aligns with other reports. So, for example, Deloitte's 2024 cybersecurity report found that 26%, only 26% of family offices have a robust cybersecurity framework, despite the fact that 57% of North American family offices have faced a cyber attack within the last 12 to 24 months. Those same numbers, even though they talk about family offices, we could apply to PTCs just as well. And also worth noting that it's very likely that a regulated public trust company with years of experience in the industry may have more robust cybersecurity measures in place than a startup PTC. The trust company can also function as a second layer that could spot potentially suspicious activity. So I would not necessarily assume that a PTC will provide more privacy protection than a regular trustee. Another reason that I hear from time to time is concerns about the fiduciary industry, about the professional fiduciary industry. And this rise in PTCs could be seen as a reflection of that. Because as the fiduciary industry has grown, we have seen that the quality of that service may not necessarily have grown with it, which leaves some clients unsatisfied with the level of service that they are receiving, particularly relative to their fees. The other part is that the fiduciary industry has gone through a period of consolidation, mergers, et cetera, and that can leave clients adrift and uncertain as to whether they're going to have the same fiduciary for multiple generations, which for a dynasty trust, for example, you want a fiduciary that's going to be there for multiple generations. It's a valid concern and really one that should give pause to the fiduciary industry to provide a better service and value proposition. That said, it is possible that the PTC will still end up relying on third-party administrator for administrative services. And it will also require the family to monitor other third-party providers and liaise with multiple service providers. So it's not necessarily that implementing a PTC will be much more seamless or smooth for the family as a whole. The other aspect that I see is generational transitions. As we see the great generational wealth transition that is underway right now, we see that families require services from multiple branches, and if using trust structures, they're going to require trustees. So consolidating services to a PTC can provide an economy of scale in which the different family branches and generations can share in the cost. So that is important, and I also see that the younger generations may feel that a better service can be provided, through a PTC than with a third party. Whether that is right or wrong really depends on the family and the robustness of the PTC. Lastly, I've also seen the PTC as a reaction to the rise of the family office. It's something that we have seen become much more prevalent, and we have seen families increasingly use the PTC as a mechanism for using the family office, for implementing the family office as part of the PTC. This could function, it could consolidate services, and it could also do so in a way that works very seamlessly with the trust agreement, with all the terms that need to be observed as part of the trust. So it could also have the added effect of observing and adhering to the governance that the family wants to employ. So with that, let's go over to the next slide, where we're going to be focusing on the typical private trust company structure. So here I presented just a very general slide. There could be very many different variations of this, but this is a potential, private trust company structure. So the first thing to consider is when you create the private trust company, who is going to be the shareholder? And typically what we see is that it tends to be a special purpose trust acting as the owner. This can be called a non-charitable purpose trust in some jurisdictions. Not every state has it, but all of the states basically that have private trust company statutes do have them. Typically, the purpose trust does not have any current income beneficiaries, and the only use of the purpose trust is to actually hold the shares of the PTC. Upon termination of the purpose trust, then the trustee or the protector, as the case may be, will name the beneficiaries that would receive whatever proceeds are generated from the liquidation of the PTC. It is possible that different family trusts could be the owners of the PTC, but note that this could result in essentially the PTC owning shares of itself, which could create some conflict of interest, with respect to the administration of the trust. There's also some laws that prevent a trustee from basically investing in itself. So you have to take into account whether any laws have to be carved out, when doing this. Although individuals in their own name can hold it, and I have seen it in the past, we do have to take into account that this creates a potential succession issue. What happens when that individual passes away? Do we have a solid plan in place for the recipients of those shares? Do we want the individuals that are receiving those shares to take? What if it's a state, what if it's an owner that comes from a forced heirship jurisdiction, and that has to go to individuals that may not even be aware of the structure? So be very careful with that. I tend to disfavor the use of the shareholding by way of natural persons. I think that could be ripe for potential issues down the line. It also potentially creates potential family dynamics that could become problematic down the line if there's no agreement between the family members and how the PTC is administered. So the PTC itself, it's typically set up as a C corporation, a limited company, or an LLC. Although in the case of an LLC, I do see that it's typically treated as a C corp for tax purposes. Whether it is a limited or an LLC may not have a ton of practical impact, although the proposed revenue ruling that we're going to be discussing later does not necessarily address LLCs, but it's kind of implied that they could fit within the rubric of what the service is proposing in that revenue ruling. I would say that the vast majority of PTCs that I see recently are actually formed as LLCs. And this might be, relevant to, for example, the LLC being able to make an entity classification election, or colloquially called the check the box election. This could be particularly relevant in the international context, or it could be relevant in other future generations if there needs to be some added flexibility inserted into it. At the level of operation, the PTC itself tends to be managed by a board of directors. This is typically constituted by family members, although there are some possible external members that could operate. That said, the PTC can offer for specific officers that can perform certain functions. This could be a chief investment officer, a fiduciary accountant, a trust officer, so on and so forth. And the PTC can also have committees entrusted to address certain matters that are relevant to the PTC and the operation of the trust themselves, such as an investment committee, a distribution committee. Some of those we're going to discuss in greater length when we actually get to the tax implication. There's also usually what I see is the best run PTCs tend to have a relationship with a third-party administrator that can basically take charge of the back office services, the administrative services, and liaise with providers. So they could take care of any crime notices, they could take care of dealing with the accounting, so on and so forth. And that tends to facilitate the operation of the PTC without necessarily having to hire up in order to be able to perform those very same functions. Usually it's going to be a lot cheaper than basically having to hire individual personnel for those purposes, which, that's the alternative. The alternative is to just hire your personnel. But again, that may end up being a little bit more costly and burdensome than just hiring a third-party administrator. In terms of the structure itself, the PTC will serve as a trustee for multiple branches of family members, multiple family members. As I've said before, usually there's going to be a designated relative that has to be named, and that could be a common ancestor, for example. And that designated relative will act as the measuring life of sort for who is going to be considered a family member. So, for example, in the case of Florida allows to be designated as a family member, and any family member is, for example, any lineal descendant up to the 4th degree if it is an unlicensed trust company, or up to the 6th degree if it is a licensed trust company. In the case of collateral descendants, they allow up to the 7th degree if it is unlicensed, and up to the 9th degree if it is licensed. So it could be a very, very broad set of family members that could fit within the rubric. Some states allow key employees of the PTC to be considered family members. Florida does not, but there are some states that do allow for that. Of course, then those trusts can own participations in both individual businesses. They can own participations in joint operations, or they could just own, the particular portion of the assets that are particular to that family branch. With that, let's go over to the next slide. We can just kind of take a look at the map here as to what is the state of private trust company laws. So you can see there are now multiple states that offer this particular type of form. And the main distinction is which ones offer just the lightly regulated model and which ones offer both the regulated and unregulated model. Do not take anything away from the colors. They're just there to distinguish. There's no bad or good with respect to this. But those are the ones that offer it. The most recent one there is Missouri. Missouri just enacted its family trust company laws this year. So they're the most recent addition. By far, the most popular state in terms of the regulated variant, I would say, is South Dakota. That's the one that we tend to see the most often. And for states that offer both the regulated and the unregulated variant, I tend to see Wyoming as the most popular one. Although I have seen states like Nevada and New Hampshire also establish a market presence. Of course, Florida enacted its laws in 2015, although to be quite frank, I have not seen as many Florida-based PTCs gain as much traction. If you're using a regulated variant, then some of the considerations when you're choosing a jurisdiction will involve, for example, the depth of the talent pool when hiring personnel, the service provider. So are there administrators, are there attorneys there that could potentially support? One of the things to consider is that some of the states, may be smaller, and so the pool of potential attorneys may not be that deep. And for example, if you're looking for litigators, essentially, this could be something that could come back to be an issue if there are potentially multiple family members and there's certain conflicts of interest that would prevent the attorneys that are there from representing different and multiple family members. Another additional consideration is the relationship with the regulator and the regulator's familiarity with the private trust company. Some states like Wyoming, South Dakota, they've had this for some time now, so the regulator is very familiar, whereas a newer state may still kind of be coming to grips with how to implement this, how to view this, and there may still be some kinks in the work there that have to be worked out. There's also capital requirements. So, for example, Florida requires $250,000 in capital contributions to the PTC in order to be able to obtain the license. So that differs from state to state. And there's also a potential surety bond or director's liability insurance that has to be obtained in order to be able to obtain the license. So Florida, for example, has a requirement of $1 million in directors and officers liability insurance, and also $1 million in surety bonds for each officer, director, or manager of the private trust company. And lastly, the other point that you want to consider is how favorable the trust laws and the courts are. In particular, some states like Wyoming and New Hampshire, they do have their own trust court, so they are able to review trust cases and trust and estates matters with a specialized trust court. So that may be something that you may want to consider as well. That said, let's go over to the next slide and let's just start talking about the general income tax considerations and the general tax considerations as a whole of using a private trust company. So the very nature of the PTC is that it's going to be controlled by the family, and that very nature implicates potential tax considerations. So the first thing we can tackle is the income tax considerations. And if we look at the income tax issues, the main issue would be triggering grantor trust status under any of the powers of 671 to 679 of the code. And if grantor trust status is triggered, then the settlor is going to be the deemed owner of the trust for income tax purposes. And it means that any tax liabilities will have to be picked up by the grantor. This can become an issue if, for example, the settlor did some very aggressive estate tax planning and did not plan to have enough liquidity to pay for the tax liabilities of the trust. Or it may simply be that the settlor said, I want to just give this out and I don't want to be responsible for any of the tax liabilities. In less likely scenarios, it is also possible that a beneficiary could be deemed to be the grantor under Section 678 of the code, but that is only if the actual settlor of the trust is not treated as the grantor under the other rules of 671 to 679. The question is whether this is really an issue, because a typical estate planning mechanism, as you all know, involves setting up an intentionally defective grantor trust, which is a trust for which the settled property is out of the estate of the grantor, but it is still treated as the grantor's property for income tax purposes. So this has the benefit of reducing the grantor's taxable estate by virtue of the tax payments. And it also means that the assets are not subject to the compressed tax brackets for trust. More importantly, it is a very important planning strategy in estate freeze transactions, in grantor retained annuity trusts, and irrevocable life insurance trusts, particularly because transactions between the trust and the grantor are not recognized for income tax purposes under Revenue Ruling 85-13. So in many cases, you may actually want to trigger grantor trust status. So this may not be the end of the world, as we would say. But this type of planning, is worth noting, has been under greater scrutiny by Congress. So if you recall back to 2021, there was the Build Back Better Act, and that act actually specifically tackled the intentionally defective grantor trust. And what it did was that it pulled the grantor trust into the estate, even though it was set up as an intentionally defective grantor trust. That would, of course, be catastrophic for a lot of the planning that we as practitioners do. And so that bill was defeated. It was actually defeated because it lacked senatorial support from the Democratic Party. But it is possible that this could come back in the future with future legislation. So the big concern with respect to the PTC, more importantly, is the estate and gift tax issues for not only the seller, but also the beneficiaries. Because the potential power to dispose of trust property by way of the PTC could result in the trust property being included in the seller's estate, and thereby undermining the careful estate tax planning that was set forth for the trust. And under the strict provisions of sections 2036 to 2038 of the code, any property that is transferred to a trust can be deemed part of the owner's estate if the seller's estate, if they retain an interest over the trust. This interest could be having an interest over income, or the power to designate beneficiaries of the trust property, or by having the right to revoke or having a reversionary interest in the trust. Moreover, if these powers are relinquished by the seller, then there's also the 3-year period that has to be observed, over which the assets will remain part of the seller's estate by virtue of section 2035 of the code. So it means that if you have a poorly implemented PTC structure, it may not necessarily be so easy to get it out of the seller's estate if they relinquish those powers. It's also important to note that there could be potential estate tax exposure to beneficiaries if they are considered to have a general power of appointment under section 2041 of the code. A general power of appointment is any power to appoint trust property to yourself, to your estate, to your creditors, or the creditors of your estate. So this could be the case, for example, if the beneficiaries can make distributions to themselves by way of a trust for which the PTC is the trustee. So that also has to be taken into account. There's also potential implications for generation skipping transfer tax issues. The most significant one is the potential loss of grandfather status for dynasty trusts. So the GST tax as it exists today set forth that any trust in existence before September 25 of 1985 is not subject to the generation skipping transfer tax. And so they're considered exempt trusts. They're considered to be irrevocable for GST tax purposes. And so making sure that you protect this exempt or grandfather status is extremely important. Because any kind of change to the trust could potentially put that status at risk. And the status could be compromised, for example, if there are any additions made to the trust, which would cause a change in the inclusion ratio for GST tax purposes, so that some GST tax will have to be observed. It could also be if a general power of appointment is granted, or if the vesting period of a beneficial interest in the trust is extended beyond the original period, or if there's a change in the beneficial interest that would shift that interest to a lower generation. In other words, any modification that is not administrative in nature could potentially put the GST trust's tax exempt status at risk. Having a PTC also has the potential to implicate the estate tax inclusion period. So this basically means that you cannot allocate any GST tax exemption during the period in which the property that is transferred into the trust is treated as part of the settlor's estate or the spouse's estate. So it's worth taking that into account. We also have to consider, if you do relinquish those powers and if the estate tax inclusion period ends, then there could be an automatic allocation of the estate tax that may not have been accounted for. So you may have to consider, when you give up that power, when you do have that end of the estate tax inclusion period, whether you have to opt out of the automatic allocation, because at worst, it's something that you weren't planning for. At best, it's something that you weren't planning for, and at worst, it's allocation that was not intended to be part of that trust. There's also international tax issues that have to be borne in mind here, and these are, for example, if you have a foreign grantor and you want to keep the trust foreign, it's important that even though you have a U.S. trustee, that at least one foreign person is able to exercise substantial control by way of a substantial decision over the trust. So substantial decision would be, for example, having the power to replace the trustee. That allows the trust to fail the control test, and that means that it becomes automatically a foreign trust for tax purposes. Because the downside to that is that if you fail that, if you don't fail that control test and that gets treated as a domestic trust, then that could potentially have disastrous effects, because that domestic trust will be subject to U.S. taxes. It will be subject to a bunch of other compliance issues. And also, if you want to exit out, if you want to go from domestic to foreign, then that would potentially trigger an exit tax under Section 684, and it would have to pick up any kind of gain that has been accrued within the domestic trust, even though there might just be foreign beneficiaries. So it's very important to plan accordingly. Going over to the next section, what does the IRS actually say about the taxation of private trust company? And unfortunately, it's an area that is frustratingly unexplored by the IRS. During the late 90s and early aughts, there were certain PLRs that were issued by the service addressing the use of PTC. But unfortunately, as of 2005, the IRS is no longer issuing private letter rulings with respect to private trust company. And the reasoning for this is that there's going to be a forthcoming revenue ruling. That proposed revenue ruling was supposed to be Notice 2008-63, which was proposed in 2008. And that was supposed to be the revenue ruling that explained and clarified the tax considerations of using a PTC. And it's important to read the purpose of the proposed ruling, as that's really going to inform a lot of the planning, the degree of risk that any given practitioner will decide to take when setting up these type of structures. So the purpose of the ruling, as stated in the proposed revenue ruling, is to confirm certain tax consequences of the use of a private trust company that are not more restrictive than the consequences that could have been achieved by a taxpayer directly, but without permitting a taxpayer to achieve tax consequences through the use of a private trust company that could not have been achieved had the taxpayer acted directly. So essentially, what they're trying to do here is avoid any kind of distortion that could arise by virtue of inserting a private trust company. Essentially, it's almost like a pass-through. They want to make sure that if you use a private trust company, that you're still subject to the very same rules as if you were exercising that power in your individual capacity. How that worked out, not very well. The proposed ruling did not go over well, and it was very heavily criticized because it contained a lot of gaps, a lot of inconsistencies, and going by its own stated purpose, which we just read aloud, the ruling failed. So the ruling has never been finalized despite undergoing the typical commentary period. I have not heard anything else as to whether this is going to be finalized in the near future, but it's still out there. So we're going to explore that ruling in a little bit more detail in the next few slides. And despite this, the IRS has reiterated its position that it will not issue PLRs on the matter, and that came out in the latest revenue RevProc, that they're just not going to issue any PLRs on the matter until this matter is resolved. So let's look at the private letter rulings. As we all know, PLRs cannot be cited as precedent, but they do give us some insight into how the IRS may consider the issues surrounding PTCs. So the first one here, PLR 98-41014, was issued in 1998, and I'm just going to give you the basic facts. It was State Limited Banking Association serving as trustee. 50% of the voting shares of the banking association were owned by Family 1, which was unrelated to Family 2. The other 50% was owned by Family 2, and the ownership was split into multiple trusts, none of which owned more than 10% of the voting shares. The bylaws of the association required at least one board member who is not a family member or beneficiary to participate. And it also prohibited board members or officers from making discretionary decisions regarding a trust for which such person or their spouse is a grantor or current or contingent beneficiary. The shares of Family 2 were then transferred to a voting trust with 13 voting trustees. So what the IRS said was that the PTC is not considered a related or subordinate party because none of the shareholding trusts own more than 10% of the voting power of the trust, and the grantor and the beneficiaries cannot participate in the PTC's discretionary non-investment decisions. And so here we see two important points come up when addressing PTCs. And the first one is that the PTC should include restrictions on who can participate in discretionary decisions with respect to a grantor or beneficiary. We typically see these clauses in a trust agreement where they say a beneficiary cannot exercise any such power for which they will be able to distribute assets to themselves, their estate, their creditors, their estate, so on and so forth, which would potentially trigger an estate tax. So those very same provisions that protect in a trust agreement need to be included in the bylaws of the PTC. The other point is that how the shareholding of the PTC is structured becomes very relevant, because it's relevant as to whether the PTC itself is considered a related or subordinate party, which may have implications for grantor trust status, and also, as we will see, with respect to whether a change in trustee could potentially trigger some sort of estate tax inclusion. We then had another PLR in 2001, and this was, interestingly enough, the same family, same petitioners reading between the line and same facts as before, except in this case, they wanted to get an opinion on the 2036 to 2038 issues, the general power of appointment issues, and the GST tax purposes. So under the very same facts as we saw before, the IRS determined that the PTC does not cause estate tax inclusion in 2036. It is not treated as a general power of appointment under 2041, and it will not lose the grandfather status of a GST tax exempt trust because the change is only administrative in nature. And again, the reason for this is that it contains those restrictions that prohibit discretionary decisions being made by the beneficiaries. We then had the last batch of PLRs before the IRS decided to just shut the door on issuing private letter rulings on PTCs and the taxation of PTCs, and this came in 2005. So they're basically same petitioners. So basic facts are that the PTC bylaws provided for discretionary decisions review committee, and this committee was responsible for reviewing the discretionary decisions such as for distributions, for example. The bylaws prohibited members of the committee from participating in decisions with respect to trust for which the member or their spouse is a grantor or a current or contingent beneficiary. The facts of this PLR are very extensive, but the ultimate ruling is that the service found that the PTC is not related or subordinate under 672, will not trigger grantor trust status under 675 or 677. It will not cause a beneficiary to be treated as the grantor under 678, and it will not cause estate tax inclusion or a general power of appointment or lose the grandfather status for GST tax purposes by virtue of these restrictions on the grantors and the beneficiaries, preventing them from exercising discretionary decisions. So again, it goes back to there needs to be limitations within the bylaws itself prohibiting those beneficiaries or the grantor from exercising discretionary distribution decisions or decisions that are more than investment, in nature, more than investment oriented in nature. So with that, let's go over to the notice of proposed ruling, and this is notice 2008-63. As I mentioned, it was issued in 2008. So Andrea, if you can go on to the next slide. I've set up kind of a very general, diagram of how it operates. Basic facts are that A and B, husband and wife, created irrevocable trust for each of their children, C, D, and E, and also for their grandchildren. C, D, and E created their own trust for their children. And the proposed revenue ruling acts under a hypothetical in which there are two different scenarios. Under scenario one, the PTC is formed under laws that include restrictions on discretionary distributions. Now, it is worth noting you shouldn't rely on this particular scenario because as far as my knowledge goes, I have not seen a statute that provides for the restrictions that the notice addresses, that the proposed revenue ruling addresses. But the IRS does consider that within this scenario, that situation one is that the PTC is formed under a jurisdiction that includes restrictions on who can make discretionary distribution decisions. Scenario two is that the PTC's bylaws include restrictions on discretionary distributions, the same that we saw under the statute, but it also includes an amendment committee over which a majority of the members must always be individuals who are neither family members nor persons related or subordinate to shareholders of the PTC. And only this amendment committee could make changes to the discretionary distribution committee, to the amendment committee, or any of the other restrictions that the notice proposes are needed in order to make sure that you stick to that safe harbor. In either situation, both situation one or situation two, the family owned all the stock of the PTC. A, C, and D are officers and directors and serve on the distribution committee of the PTC. B and E are only shareholders, they're not officers, but E is an employee of the PTC. The PTC is then appointed as a trustee of the trust, replacing a financial institution as trustee. So going over the next slide, what are the restrictions that the IRS noted were relevant to making sure that it didn't trigger all the tax implications that they wanted to address? So the first one is that they require the establishment of a discretionary distribution committee. We've gone over that, and the members of such committee and their spouses cannot participate in discretionary distribution decisions for the trust over which that member or their spouse was a beneficiary, or for a beneficiary over which such member or spouse has an obligation to support. Again, going back to preventing grantor trust status and making sure that there's no estate tax inclusion. Also, only officers and managers of the PTC can make decisions regarding personnel, such as the hiring, discharge, promotion, or compensation of the private trust company's employees. This was very vague, but the presumption here is that they are trying to ensure that the PTC is not treated as a related or subordinate party. Again, this being for reasons of avoiding grantor trust status, so on and so forth. Another restriction is that nothing in the governing document can override a more restricted provision in the trust instrument, and also that no family member can enter into any reciprocal agreement with another family member, either expressly or implied, regarding discretionary distributions. And also, the Amendment Committee has the sole authority to make changes to any of those restrictions, and the Amendment Committee itself. And the Amendment Committee must be constituted by a majority of members who are individuals who are neither members of the family nor persons related or subordinate, as defined in Section 672C, to any shareholders of the private trust company. So the IRS basically blessed this and said, for this purposes, income tax will not result in grantor trust status, even though they said that for 675 purposes, there might be a question of fact as to how it actually is operated. 674 is avoided because grantor can now make discretionary distribution decisions. For estate and gift tax purposes, is not included in the estate of the grantor, and gifts are going to be deemed complete upon transfer. For GST tax purposes, consider that it's not going to lose grandfather status, it's going to be exempt, and in other words, it's a change that the IRS considers purely administrative in nature. If you're a tax attorney, as you most likely all are, you're going to start spotting some issues with this that are potentially relevant to how you're going to structure. So going over to the next page, let's highlight some of the issues with this proposed ruling that potentially make it a lot more restrictive than they need to be. So the first question is, why can't spouses serve on the discretionary distribution committees if they could make those decisions for estate tax purposes if acting in personal capacity? So the problem here is that the service seems to have tried to just block out the sun with one thumb, and they've wanted to cover both the grantor trust issues and the transfer tax issues at the same time. And in trying to find a perfect solution, they basically created restrictions that are applicable for grantor trust purposes, but they're not necessarily applicable for transfer tax purposes. So the spousal unity rules of 672 in the grantor trust rules require that any grantor will be attributed the qualities of their spouse, so that you will have a grantor trust if the spouse holds the same powers, but that does not necessarily correlate to the estate tax inclusion. So it should not be an issue, for example, if the spouse acts as a trustee for a trust over which a child is beneficiary. Also, why are spouses of beneficiaries precluded from being on the committee, for that matter? There's really nothing that would prevent them from doing so and potentially cause estate tax inclusion. The other big issue, of course, is why can't a beneficiary participate in distribution decisions if it is based on an ascertainable standard? If you have a person acting in their individual capacity, say you have a spousal lifetime access trust, a SLAT, that SLAT could provide for the spouse to make discretionary distribution decisions if it's based on a health, education, maintenance, and support standard. That should not be an issue. So why is it that by virtue of just using a PTC, you are now precluded from doing so? It creates a distortion, which is exactly what the IRS wanted to avoid when it issued notice in 2008. Another question, does Revenue Ruling 9558 apply? So this is the safe harbor for which the grantor will not trigger estate tax inclusion if the power to remove and replace a trustee can only be exercised if it is for a related or subordinate party. That, of course, also has implications towards the beneficiaries. Question, does that mean that any kind of replacement of a member of the discretionary distribution committee could trigger estate tax inclusion if it's not related or subordinate? It's simply not clear within the notice itself. Another point of notice, there's no real clearance on who exactly is the beneficiary. There's no distinction between current income beneficiaries, remainder man, or even contingent beneficiaries. So potentially you have beneficiaries that could take three, conditions down the line that are prohibited from exercising that control. And one of the issues that you see with this notice in particular is that the restrictions are so unduly burdensome that you could potentially see a scenario in which it's very difficult to find someone that fits within the rubric that the notice has set forth. And so it kind of dictates that you take a more reasonable and rational view by virtue of analogy to what would happen if it was exercised, if those powers are exercised in personal nature. Another issue relevant to international tax practitioners is whether the trust fails the control test for tax purposes if non-US persons have substantial decision-making powers through the PTC. In other words, would you look through the PTC to determine whether it fails the control test for tax purposes? My opinion, I would presume not, because the PTC is a US person as defined by the code, but it's also an area that is left open in the proposed ruling. Also, for that matter, could non-family member shareholders make amendments to the amendment committee? It's not likely possibly to have non-family members, being shareholders, but it is possible, and it's just not clear within the proposed ruling as to whether it's possible. Another area that I didn't indicate here, but there's also not a lot of guidance on 2036B and when a grantor can basically exercise powers through the PTC in controlling stock of corporations owned by the trust. That's an area that's left very vague within the notice, and that certain practitioners ask for additional guidance with respect to that. Also, life insurance and incidents of ownership, that's also something that was not very, it just wasn't addressed within the notice itself, and additional commentators asked for guidance on that point. So with that into account, and with those issues, we can go over to the next slide and consider some of the potential planning that could be done in here. So, of course, if you want to be as conservative as possible, and Andrew, if you can go over to the next slide, if you want to be as conservative as possible, you basically observe all the potential restrictions that are required of in the notice. And actually, go back to the preceding slide, Andrew. I'm sorry. You observe all of them, and you basically go as restrictive as possible. And at the very least, you have reasonable assurance that no estate tax inclusion or grantor trust status will result, because you've taken a very restrictive definition. However, that could be more restrictive than it be, and because of the holes that I just pointed out with the proposed revenue ruling, it is very possible that final ruling, whenever that actually comes into place, is going to be less restrictive. It's going to be less restrictive than what we have here in this notice. Perhaps it's going to split, the grantor trust issues from the transfer tax issues, which would make it a little bit more manageable. But as a baseline, as planners, we should have certain provisions in place. So, of course, we should have a discretionary distribution committee, and this committee should have restrictions over which the grantor or the beneficiary cannot participate over discretionary decisions for trusts over which they are a grantor or a beneficiary. There should also be an amendment committee. This amendment committee could preclude changes to the discretionary distribution committee, to the amendment committee, or any of the other restrictions, unless it is made by a majority of non-related or subordinate parties. And also, there should be a provision in the bylaws prohibiting any reciprocal agreements. I mean, this is just common sense, but it's worth putting it in there by virtue of it being included in the notice. But if we take the stated intent of the service of not causing any distortion by virtue of using a PTC, then we should feel a little bit more comfortable in analyzing the rules applicable when acting in personal capacity to when acting through a PTC. Now, the degrees of risk with respect to this potential alternatives varies, and it's up to you as a practitioner to determine how much risk you want to take. But one thing to take into account is potentially we could preclude the settler from serving in the discretionary distribution committee, but not necessarily the spouse. So this will give us one of the guardrails necessary to avoid estate tax inclusion of the property, but it would potentially cause grantor trust status. So we could also allow beneficiaries to participate in decisions for HEMS for any ascertainable standards. So if they're part of the discretionary distribution committee and there's a distribution for one of the trusts for which they are beneficiaries, they could make decisions if it's limited to a reasonably ascertainable standard. We could also allow spouses of beneficiaries to participate in discretionary distribution decisions, or allow non-family member shareholders to participate in amendment decisions. We could also allow beneficiaries to make personal decisions, excluding the discretionary distribution committee. But with respect to that, we could allow the appointment of members of the discretionary distribution committees, but only perhaps if they're not related or subordinate. Again, the degree of risk with respect to this varies, and it's up to you to determine how much you want to include there, taking into account that the IRS may later come and provide more guidance on how this actually will be viewed. Note, however, that any kind of restriction should be made before the PTC is acting as trustee in order to avoid any potential estate tax inclusion issues. And I hear Andrea is cutting me already, so let me just finish out. Last slide, just real quick over the regulations. If you can, Andrea, just cover the last slide. Note that there are going to be annual filing requirements that you're going to observe as part of the PTC. You do have to designate a relative, whether you're a regulator or unregulated PTC. There are potentially capital requirements if you're a regulated one. There is potentially a liability insurance and surety bond that has to be obtained. At the federal level, there are tax filings that have to be made, even if there is not a lot of income. Form 1120 for corporate tax returns, Form 1065 for partnership tax returns. And also take into account that there might be foreign bank account reporting requirements if it is this U.S. person holding accounts in foreign jurisdictions. Also, Corporate Transparency Act, we all know that it's been enjoined, but whenever it comes down, whenever it actually gets to go forward, this PTC will have to report for the Corporate Transparency Act, and it will have to report its beneficial owners, meaning people that have substantial control or the actual shareholders of the company. One last point, in order to avoid being treated as an investment advisor under the SEC's 40s Act, the PTC needs to qualify for the family office exclusion. So the family office exclusion basically says that it's a family office excluded from being treated as an investment advisor if it has no clients other than family clients, it's owned wholly by family clients or exclusively controlled by family members or family entities, and it does not hold itself out to the public as an investment advisor. This also exempts from state requirements because of the federal preemption rules. So it's very important to qualify for this if you are setting up a PTC. Lastly, Regulation S, that's a safe harbor that is meant to exclude foreign issuers of securities from registration with the SEC. The one big condition is that they cannot market their products to U.S. persons. Here, a trust with a U.S. trustee would very clearly be a U.S. person. So they would not be able to invest in foreign mutual funds. So if you have a foreign structure with U.S. trustee, then you might have to consider how to avoid Reg S, how to get out of Reg S. That could be, for example, by having a co-trustee that is foreign that makes all the investment decisions, or having an investment manager that makes all the investment decisions and is foreign. So that's it, Andrea. Kick it over to you. Any questions from Zoomland?
We have no questions. I just wanted to reiterate the CLE code for today is 8711 for those of you that have to jump off of the CLE right now. Thank you so much, Osvaldo, for the CLE presentation today. And I also want to thank Tim Bronza for also joining us today. We really appreciate all of the support from both of you. Once again, that CLE code is 8711. I don't see any questions in the Q&A, but anyone is welcome to send their questions and we'll be happy. I'm sure Osvaldo will be answering to answer them. Do you have your contact information on here? Would you mind anyone?
I think I do have the contact information, but if not, feel free to reach out. I also want to note that if you do have any questions, always happy to talk. We also have the handbook that was created by Todd Mayo. He was the consulting editor on that, and it was published by Globe Law on private trust companies. That's where I included one of the chapters on taxation and regulation of private trust companies. That's available. It's in its second edition now. That was issued in 2023. So if you want to have a handbook on the particular topic that covers different considerations, covers multiple jurisdictions, then that could be a very good resource for everyone. Happy to also share my side of the chapter for free. If you ever need it, I'm happy to share that. And send it over to everyone. But yeah, certainly if you have any questions, feel free to reach out. Again, this is a topic that I've been intimately involved with over the years, and it's always fun to talk about.
Well, thank you everyone for attending. We appreciate it. And thank you, Osvaldo. Thank you, Tim. We appreciate your support today.
Thank you all.
All right.
Bye.
Have a great day, everyone. Thank you.